one of the rights that a tenant has under Landlord and Tenants Act is what we refer to as quiet possession.
Yeah, today we are here to break down the Landlord and Tenants Agreement.
There is a law that governs these agreements. It's called the Landlord and Tenants Act.
And also landlords are doing things that are really catastrophic in nature.
Cutting off water and electricity to the premises, even if the rent is outstanding, is illegal.
Hello everyone, my name is Chomwede Ignatius and with me is Moses Ngoroka. Yeah, today we are here to break down the Landlord and Tenants Agreement. Many youths, we've seen that they are having a lot of grievances, conflicts with their landlords, and also landlords are doing things that are really catastrophic in nature because probably maybe people don't know their law or they don't know their rights as tenants. But today we are here to break down it for each and everyone to understand their rights and responsibility as a tenant and their responsibility as a landlord. Moses, can you introduce yourself?
Thank you very much, Ignatius. I'm pleased to be here once again. It's great to continue what we were doing last year, to be able to disseminate what I believe is key legal information to the public. So excited to be here. My name is Moses Ngorok from Legal AI Africa. We provide legal technology tools, to the public, lawyers, companies. These are AI-powered tools that help people access legal information and resolve legal issues. Currently, we have free AI legal assistance. You can ask questions and get answers. And we're also working on a fraud detection tool for land titles and car logbooks. Yeah.
Okay, thank you so much. That's
Yeah.
so brilliant.
Thank you.
Firstly, my question is or will be like many of us, we are asking ourselves,
Yeah.
where agreement here and there, but where do these things derive their validity from, or which laws are governed by these agreements and what and what?
Yeah, of course, agreements are part of society. Even, before we had written agreements, people transacted. Agree, you speak, say, I want this, the barter trade and the like. And of course, so what we are discussing today is just a unique type of agreement where someone has a property and another needs to use that property for whatever reason. It can be for commercial or for residential purposes. So the two speak and agree that this amount will be paid monthly to the owner. So that is what a landlord-tenant agreement is, essentially. So it is something that is not new. We are Africans. Sometimes we think that the law came with colonialism, but in the past, people used to rent. They used to rent land and even for farming. Yeah.
Okay. Actually, I think in my own perspective, I thought that, just like the way you see things coming up and you are questioning yourself where they, but since now I've come to know, because in your own explanation, you're saying that they came way back from the colonial rule or
Even
from
before.
the colonial era. Yeah. So
Yes.
really they are so valid.
Yeah.
And probably my second question could be, is a landlord tenant agreement really so valid in nature, because many of us have gone not without these things or without these agreements? How valid are they?
Okay, true enough. Yeah, thank you. That's a good question, Ignatius. So there's a law that governs these agreements. It's called the Landlord and Tenants Act, Chapter 238. So if you're watching right now and you want to learn more and read it yourself, you can go Google. There's a website called Yuli, which provides free legal information, or you can use a chatbot like Legal AI or Gemini or ChatGPT and ask it. Being mindful, of course, that AI tools are not fully accurate. Yeah.
Sure.
So here's the thing: within that law, it provides for oral and written agreements. So an oral agreement can be valid to establish a landlord and tenant agreement if the oral agreement is the tenancy or the amount paid is not more than 500,000 per month. If it is more than 500,000 per month, it must be written down.
Okay.
So oral agreement, so a landlord agreement can be either oral or written. And by written we mean it can be written in hard copy, or it can be reduced into a data message like WhatsApp. So even WhatsApp can amount to the viewers, a WhatsApp message can be an agreement.
Okay.
However, if it's above 500,000 per month,
Then
written down, then also
agreement.
it must be in Uganda shillings,
Okay.
not in dollars. So if anyone is there charging you your rent in dollars and you're in Uganda, that is illegal. Yes.
Oh wow, that's so awesome.
Yes.
So for my viewers, I think you can see these are things that have been happening to us, have been happening to you exactly.
Yeah.
But now it's time for you to learn and
Yeah.
understand specifically what you ought to do.
Yes.
Another question is like, what are those specifics exactly? Like, I want you to detail it. What are those specifics that are supposed to be in the landlord-tenant agreement for it to be valid? Because for any agreement, maybe for example, there should be a signature or what. So like, I want you to tell my viewers or our viewers to know that what exactly is that supposed to be in the in this agreement.
Ignatius, today you're coming with very brilliant questions. Not that other days you don't ask brilliant questions, but yes, they are brilliant questions.
Yeah, sure.
Yes, we can refer to them as the essential features of a tenancy agreement. Yeah. Number one, naturally, you have to have the names of the parties. So you make sure the correct names, the names that are on the national ID, or the national ID if you're Ugandan. If you're a foreigner, a passport document, the passport. So you make sure your names are correctly mentioned. So the landlord's name, your name. Also be mindful that the landlord can be a company. So, and the parties can be artificial persons. So it can be natural persons as a human beings or companies.
Okay.
Companies, trusts, cooperatives. So don't be surprised when you see a name of a company in a tenancy agreement. So names first. Number two, you must also attach those ID documents. So you will not be allowed under the law if the tenancy is above 500,000 to contract if you don't have a copy of your national ID. So that is if you're Ugandan, or a passport if you're a foreigner.
Okay.
So that is important. If the tenant is a company, then a certificate of incorporation. That would be important. Or whatever other type of legal entity. At least you have to have a certificate of registration.
Sure.
Yes, that is important. The other thing that you need to mention is obviously the amount. The amount of rent that has to be clear so that the parties are clear on the obligation, on the tenant's obligation to pay rent. The next thing is you need to also mention the duration of the tenancy. How long is it for?
Okay.
I think that is very key. So a tenancy can be monthly, it can be weekly, it can be annually. It can be drawn to be annual, or even for 10 years.
Okay.
Then the other thing that would be very important is, of course, the parties have to sign. Yes, you make sure you sign with your correct legal signature, the one on your national ID.
Okay.
You can either sign electronically or you can sign physical copies. Yeah.
Okay.
Physical copies.
Then also maybe you can also put your thumbprint.
Yes. So
sure.
So in case you happen, maybe you can't read and write, which is understandable.
Yeah, sure.
You can use a thumbprint. Yeah, and then the agreement must be translated for you. Someone must explain it. If you don't speak, so the tenancy can also be in any language. Yeah, it doesn't have to be in English.
Sure.
Yeah, so long as it's the both parties understand the language. But if they don't, you have to attach a certificate of translation just to show that, whereas it's in Luganda, it has been explained to the party who does not understand Luganda what it's about.
Yeah. Okay. Thank you so much. That's so good. You've talked about in some of your statement, you've said that there is where they actually stipulate the value or the monetary value that someone is supposed to be paying.
Yes.
And we are, for example, we are contracting, me and you.
Yeah.
You are my landlord and I'm your tenant, right? And it so happens that in the agreement we put there, I'm supposed to be paying 1 million per month. And I'm asking myself now, what if maybe for example, you're seeing that the city is growing each and
Yeah.
every day, yeah,
Mm.
and places are hiking their prices, like rent is hiking day and night. What is that procedure you're supposed to take that for the landlord to hike their rent, and you find that it's not inconveniencing the
Yes, yes.
tenant?
That's true. That's actually something that is covered in this law, which was passed in 2022. So this law introduced the concept of rent increment. So the law states that a landlord can only increase rent once a year, every 12 months. But even
Okay.
so, can only increase by 10%. 10% means that if you were paying rent of a million, if the landlord chooses to increase, and this increase must be the tenant must be notified, given at least 60 days notice that there's going to be an increment. So every 12 months, the maximum, if you're paying 1 million, the maximum the landlord can increase by is 100,000, because 10% of a million is
100,000.
100,000.
Sure.
So the other key feature, I think I should go back to the other question. A key feature that you would have in your agreement is obviously a description of the building that you're renting, that will mention you're renting this amount of space, on this floor, if it's a storage building. Understand? I think that's a very key thing to mention.
Okay, that's
Yeah.
so good.
Yeah.
Now, also to go back to that previous question,
Yeah.
like we are talking about in the agreement, we are also now stipulating, or we are describing the building.
Yeah.
Now, doesn't it also now come to affect the rent? Because you find that, for example, in probably in Kansanga, you find that Gawa corridor, people are paying rent because of some things, but the houses they are staying in, really, they cannot relate with the money that they are paying. Is that, can you try maybe to relate with that and tell us, is that something that can be dealt with the landlord? Because someone cannot really rent a house that is leaking and they are putting it on a certain amount of or the rent is very much, but it does not fit really in the house. Yeah, can you talk about that?
So that's true. That's a good question. Of course, naturally, the landlord tenant agreement is governed by the forces of demand and supply. So you find that the going rate for a property like rent in one area will be different from the rent in another area.
True.
And like you've said, sometimes the properties are not up to speed. In the law provides that Landlord and Tenant Act. It provides that it is the duty of the landlord to ensure the house is in good repair. That's it. Like it's what we call, it's hospitable. The house is someone can stay there, and it's not leaking. So where that's the case, actually the tenant, the law gives power to the tenant to make repairs. So long as they notify the landlord, and if the landlord takes more than 14 days to make the repairs, the tenant can go ahead and repair.
Okay.
And once they repair, they can then issue an invoice
Okay.
to the
To the
landlord.
Okay.
Or alternatively, that amount can be deducted
From the rent. Oh, that's good.
But that is after you've given
Notice.
and the landlord does not act.
After what period?
14 days.
Oh, wow.
Yeah,
Okay.
after 14
It's
days.
ample time.
Ample time.
Yeah.
Or conversely, it's also the same. The reverse is true. If a tenant has destroyed something in the house, and the landlord wants it to be fixed,
Yeah.
and the tenant does not fix it within 14 days, the landlord can then go
on and
repair it, and then
give the invoice to
the
that,
tenant.
and it will be increased on the rent.
Yeah,
Okay.
they would expect them to pay it.
Oh,
Yes.
okay.
Can
That's
expect
good.
them to pay it.
Wow.
So, however, just still on that point, under the law, it's the landlord's duty to manage the exterior of the property, making sure that the outside common areas, if it's a condominium, like swimming pools,
Mm.
compound, are in good what?
Good
Repair.
con-
It is not the duty of the tenant.
Yeah.
Yes. But then also it's the duty of the landlord to repair the property for damage that occurs from normal wear and tear. There's
Okay.
damage that normal wear and tear means that it's things, it's proper assets naturally depreciate.
Mm.
Maybe rain hits the
Yeah.
windows and
Yeah.
they get
Sure.
old, the color comes off. So it's not arising from the negligence of the tenant.
Sure.
Then it is the tenant's duty to repair anything that is damaged due to their negligence.
Yeah. Sure.
Yes.
Okay.
Eh,
Wow, that's good.
yeah.
Yeah. So to continue with,
Yeah.
we've talked about the wear and tear and what there, but we've not seen specifically the remedies in case of increment of the rent. I mean like not notified, okay, things of the kind.
Mm-hmm.
Yeah. What are the remedies for this tenant that is really they've maybe spent in the house for maybe a given time of period,
Mm.
maybe say 2 months, and now the landlord wants to increase the rent, but they really don't know where to go. They don't know where to get redress from. Yeah, sure. So how can they really get helped?
Yeah. So the first of all, an increase that goes against the law is illegal.
Mm.
So it's not enforceable. So that means a tenant can report the same to their LC1.
Okay.
You can report to the LC1, inform them that this person is acting contrary to
To the
the
law.
law. You
Mm.
can also report to the police
Mm.
that issue. Yeah, you can.
Okay.
So that is what you would do. And it's quite clear because the law stipulates and says you can't increase. Yeah.
And it
So,
is supposed to be done yearly, once in a year.
yes,
Sure.
yes, yes.
Okay. My lovely viewers, today they are really going to act positively because many of us are victims of such, and we are really facing a lot of havoc
Yeah.
because we are tenants and some of us are landlords, but we don't know really what's happening. But today, I think you're good to go. So, what is the procedure that must the landlord follow before evicting? Okay, before we even dive into that,
Yeah.
we've had this one has been given an eviction order. This has happened. This and this has happened. Really, like, what is the cause? What could be the cause of one to be evicted?
Yes. Yes. So eviction refers to an action where the landlord repossesses the property, so re-enters, because one of the rights that a tenant has under the Landlord and Tenants Act is what we refer to as quiet possession. Quiet possession means that once the tenant has fulfilled their part, they have paid the rent, the landlord should not be interfering, entering into the property without notice. So that is what we call, by quiet we mean someone should be able to relax, spend time there, and not be worried that some people will enter into the property without permission.
True.
Because for a landlord to enter into the property, they must give notice, at least 24 hours notice, unless it's an emergency.
Okay.
Like maybe there's running water, fire has what? Has started. Then, of course, reasonably, if someone has to enter, you can't start writing letters at that moment.
True.
Yeah. However, in terms of eviction, so one of the instances is where the tenant does not pay rent,
Okay.
because that is at the crux of the what? Of the relationship.
Sure.
We call it of the agreement. The agreement is obviously, it's a commercial
It's a commercial transaction.
that
true.
you pay me something, in
Yeah.
exchange you get this
You get
space.
this.
So if you fail to pay, then the landlord is supposed to report.
Okay.
Yeah, report if you fail to pay for 30 days. Then the landlord can take action, report to the LCs, go to court, and get a court order, and then they come together with the LCs and the police, and then evict.
Okay.
Yeah, so it's nowadays, it's in the old laws, it was okay for a landlord to come and attach property. What we used to call distress for rent.
Okay.
Could come and attach your TV, your sofa, but now it's illegal. That is illegal for the landlord to do.
To attach your property
Yes.
for meeting your dues.
Yes. Even cutting off water and electricity to the premises, even if the rent is outstanding, is illegal.
Okay.
The court decisions have stated that
Wow.
it's illegal. So the real procedure is to go to court, get a court order, and evict. And then regarding the outstanding rent, if the outstanding rent is less than 10 million, there is a fast process, and I'm now speaking to landlords here. Today we are speaking both to landlords and tenants.
Yeah, sure.
So we're not siding with anyone.
We're
We're just
not
hoping
sidelining with anyone. Yeah, sure.
both parties will benefit from this
Sure.
information.
Very true.
So we're saying that the landlord can also follow an express procedure that is called small claims. Small claims procedure is it's a special court that handles transactions or amount that are less than 10 million.
Okay.
So if you rent, so you can go there, you don't even need a lawyer. Go. There are simple forms that you fill in, and it's an expedited process of getting court decision. And then from there, you can then come with the LC. It's important because the law provides you have to move with the LC.
Yeah.
So that the eviction is witnessed. And
Sure.
that is how you evict someone. Yeah. So that's how eviction happens. The word eviction is really forceful removal of the tenant.
Okay.
Yes.
There is a friend of mine who was renting in some place there.
Yeah.
This person happened to he was residing there, but they happened to skip 2 months without paying this landlord. But they promised that they would pay them, and the landlord consented. Though they did not make an agreement per se, but they really made a verbal agreement or an oral agreement that by the end of this month I'll pay. But before the month ended, they happened to find their house locked. Nothing is there. Actually, they found another tenant in the house, and when they tried asking for their property where it is, they were nowhere to see the property. When they tried asking for the property, the landlord just chased them away. So, like, in such a manner, or what would be the redress of such an incident?
Well, so the thing is, when the agreement is written, so any modifications to it should ideally have been written.
Yeah.
If it's like a WhatsApp message, you said it was oral.
Yeah, sure.
Completely oral.
Oral, yeah.
So the modification should have been what we call amending the agreement. If you're amending your agreement, amending means you now agree and change the terms.
Yeah.
You get it? So it should have been written down.
Okay.
So that to be enforceable. Otherwise, now there is no evidence.
Yeah.
You understand? And so then we revert to what the law says, which is you had said he was away for 2 months.
Yeah.
So the landlord has, after 30 days, has the right to go and get a court order.
Yeah.
But in that case, in your case, it was illegal if the landlord did not go to court, obtain a court order, which you're saying he did not. He just closed the doors. That is illegal. He needs to get a court order to evict, to repossess the property.
And what about the property? Like, can it act as lien for repayment of the dues?
Yes, it can, but like I said, it will be after the court order has been issued.
Okay.
Because without a court order, distress for rent cannot be enforced. Distress for rent is a mechanism where a landlord uses the tenant's property as a substitute for payment.
Okay.
So the fridge, the cooker, the furniture, but now that's not allowed. Okay. So the use of kanyamas is no longer what? The kanyama culture is no longer the case. So we don't use kanyamas.
Okay.
You have to go to court.
And for that, I think when you're attaching, you actually have to attach what is equivalent to the rent, not awesomely. Like, for example, if the property is maybe amounting to maybe say 20 millions and
Yeah.
the rent is around 1
Yeah.
million, really, that is a very big gap between
Yeah.
the rent and the what and the
The court order
property.
will allow the landlord to get valuers. So even the tenant can get their valuers.
Yeah.
Then they value the property.
Mm.
The valuer prepares a report and says, well, that those chairs are maybe 7 million. And so that you agree that people who are trained to value assets. And so they can provide their opinion. Of course, they will charge for that service.
Yeah.
And then both of you can rely on that report. Yes.
Okay. That's so awesome.
Yeah. Also, there's another key feature of these contracts is something called a security deposit, which is very contentious.
Okay.
The security deposit is essentially a guarantee. It's an amount that a landlord takes because they want to be able to make repairs should any damage happen when the tenant is leaving. Should any damage be assessed and seen on the property, he or she or it, if it's a company, would like to have some money that they can use to make these repairs. They don't want to have a situation where now the tenant is leaving and then they have to beg the tenant for money to make repairs. So they want to have it in advance. So it's an advance payment. However, this payment is held. It's held with a condition that it will only be used for repairs, should there be any. If there is no damage to the property, that amount is supposed to be refunded to the tenant.
So that means it's not part of rent.
It's not. That's why you'll see in some tenancy agreements, they will say the rent is 3 months in advance. And by the way, let's mention that the law does not allow landlord to charge more than 3 months rent in advance.
Okay.
So the most you'll be seeing is 3 months, then plus 1 month for security,
deposit,
which is usually the equivalent of 1 month rent. So the landlord keeps it. So even if you stay for 5 years and you do not damage the property, at the end of those 5 years, as a tenant, supposed to receive that money back. However, even if there was damage, you receive to the extent of the damage. If only like you deposit like 800K and the damage was 200. Then the 600 should be returned to you as a tenant.
Wow, that's so nice.
Yeah.
Hope the questions have been answered. Many of us have been having very many questions, and hope your hope has been gotten back. Landlords, let's treat our tenants very well, and tenants, please, let's fulfill our obligations as tenants. This has been the Nalo podcast. Please subscribe with us, follow us, and with me here is Counsel Moses Ngorok. He's the CEO of Legal AI Africa. Please, you can go on your Google, type in Legal AI Africa. You can find very many things there. Make contracts with this AI, make agreements, and more of it. Yeah. Thank you so much. Thank you for following us. Goodbye.